We're now joined by a legal expert, Advocate Romeo Nthambeleni, as well as a professor in public law, associate professor in public law at the University of Cape Town, Professor Cathleen Powell. Thank you both for being with me. Let me start with you, Advocate. It's been said that the former president is testing our legal system, testing it to its limits, perhaps. Is tomorrow another example of that?
Yeah, indeed. Thank you, and good evening to you and the viewers. I think that's practically correct, and I believe my colleague will agree with me there that when we teach the students, we teach them about the supremacy of the Constitution and the law, that the Constitution is the supreme law of the land. Any act or any conduct that is inconsistent with it should be dismissed as such. So I think in the way that you have presented him, he has been a very good textbook example of a president that has actually had a lot of litigious matters that were in our courts in South Africa for over a long period of time. So that's quite correct. Tomorrow is another test, and we will then have the eating of the pudding in its eating tomorrow when the matter is being heard before the Constitutional Court.
So, Professor, the former President Jacob Zuma is claiming a lot of things, and he has said publicly that there's a conspiracy against him involving judges. On the other side, some people believe he's actually been given some sort of preferential treatment by being allowed to approach the court in this way. Just tell us, how unusual is it for the Constitutional Court to even hear an application for a rescission order? And how unusual is it to receive a rescission order?
It's very, very unusual, Francis. And in fact, the last one was from two judges of the Constitutional Court themselves, Judges Jafta and Kabenda. And they asked for a rescission of the Constitutional Court's decision not to hear an appeal from the SCA against a case that they themselves had brought. And they asked for the right to appeal to the Constitutional Court. The Constitutional Court, in a conference of judges, which is the usual place where that decision is made, decided not to hear the appeal. And these two judges applied for a rescission on the basis that they hadn't been at that conference. Now, that application was turned down without there being a hearing on the rescission matter. So not only to have a rescission application is very unusual, but to actually allow the parties who brought the rescission application to argue it before the court is, I think, unheard of. I think this is a first, and I will rely on Advocate Romeo to correct me if I'm wrong. But I think this is the first time the Constitutional Court has ever agreed to actually allow
Well, let me ask you then, do you think it's preferential treatment, Professor? Then we'll ask the advocate as well.
Yes, I do. I think that this is preferential treatment. I think it has also been preferential treatment when he refused 3 times in a row to actually turn up at the Constitutional Court, and the court still took the trouble to say to him, look, if we were to find you guilty, what sort of sentence do you think would be appropriate? Now, preferential doesn't necessarily mean unlawful. I think in this case, we can all see that the courts are not just being tested, they're being played. And because there's been so many allegations of bias against the courts, I think they are trying to be very careful not to make decisions summarily without considering all the arguments, not only to do justice, but to allow it to be seen to be done. Yeah. So that might be why he's getting the preferential treatment, those kinds of courtesies. But he is definitely being treated better than any other litigant to the court has been treated so far.
Advocate, do you agree?
Yes, Francis, I think I agree with that point. I think if it was you and me or my colleague, they wouldn't have been extended these cases. The Constitutional Court is not a playground where you will go and then seek orders to be rescinded willy-nilly. I think that is a very important point that we really need to make. But I think this olive branch that is being extended is exactly what my colleague is actually saying, to read the mood of the society and try to extend justice to him with a further opportunity to come and argue and show cause why the order should be varied. But the question is whether that variation from the reading of our papers pass the test of Rule 42 read with Rule 29 of the Constitutional Court? That is the important question that we should be asking ourselves, because my colleague has rightfully said that there has been so many opportunities that were presented to the former president to actually come to court and give his side of the story, because it's not like in terms of what is written in terms of his age and other circumstances, the court wouldn't have considered it. But when the court was making the decision, they never had that in their hands. And now the court is faced with a situation of allowing a president to say that if we set this aside, are we not going to open the floodgates to say each and every one must be treated equally before the law? And that is what is important. And we have already.
Advocate, are you saying that there's a problem here when the Constitution says everybody is equal before the law and the treatment he's being received? Or is it, as the professor says, maybe sometimes preferential treatment is justified given the nature of the case and the litigant? I don't know.
Yeah, she's correct. I think we are in agreement that so you can justify it, but the most important question that we should be asking is that, are we going to apply this treatment to everyone? Because the Constitution says that everyone is equal before the law. But here we are dealing with a former president. We should not forget about that. And I think that is important. So what she's saying is important to say. They are extending the courtesy so that we bring finality to this matter and also open him a last opportunity to be able to present this side, because you can hear that there's an issue being bandied about that he never got a trial. While people are forgetting that this is a hybrid. It started at civil and it ended in criminal proceedings. And the professor has correctly stated it out that the former Chief Justice has extended courtesy again to call him to say, if the Constitutional Court is to find you guilty of contempt, how do you think we should handle you? And if that evidence was presented of sicknesses and medical records and everything, I'm sure we could be talking a different language altogether now.
Yeah. Okay, so now you're mentioning the things that are mentioned in his heads of argument that will be ventilated tomorrow. So Professor, let's start with that claim. That's a relatively new claim that he's being imprisoned without a just trial. And this is all about direct access that the Constitutional Court gave to the Zondo Commission. Your thoughts on that argument? I think he's even now saying that it was illegal for the Zondo Commission to change its mind and not go to the police and the courts, but go straight to the Constitutional Court.
Yeah, he's calling it unconstitutional. He's calling a judgment of the Constitutional Court unconstitutional. Yes, there's several points that we need to understand about this. First of all, the court wouldn't be changing its mind. It granted direct access. Commission first came to ask for an order compelling Zuma to go to the commission. At that point, Zuma didn't bother to take part in the proceedings. He claims in his heads of argument it's because he was confident that the claim for direct access would be turned down. Now, it wasn't. The case was then heard as an urgent matter and as a direct access. He was then found to be in contempt of court, and when it was found that he had to testify before the commission. When he failed to do that, there was then the follow-up for a contempt application. Again, he said, now that shouldn't have been allowed by direct access, and he didn't know it was going to happen. But it already happened. He knew. But by now the matter was being treated as an urgent one for the sake of getting the commission's work done on state corruption, which we all agree the public has an interest in. So yes, direct access to the Constitutional Court was granted, and he knew that. He knew that after the first case that it was going to continue at the court. The second thing to note is that he's not an accused, and it wasn't a criminal trial. And the majority and the minority disagreed on this point, and they make it very clear which position they're holding. But the fact that there's a minority judgment doesn't make the majority wrong. The majority is binding, and it's a decision on the merits. And Zuma cannot, in the course of a rescission application, try to get that overturned. What they did was they dealt with the fact that contempt proceedings are they're not criminal proceedings. They're different. There's a hybrid of civil and criminal, as the advocate said. And it has been accepted by our Constitutional Court in previous cases, all of which the majority cited, that you can have punitive sanctions, a criminal sanction for contempt of court, even if the context is a civil trial.
Okay,
so Section 30.
So let me go to the advocate then. So if this is a non-starter, the whole thing about direct access, advocate, you mentioned that the whole health thing has come up in Zuma's application now. The claim that he went to go and get medicine, that's why he left the Zondo Commission, that he is of ill health and this could be a death sentence. So you said we could be having a different argument if he had brought that up at the Constitutional Court in the first place. How will the court deal with it now, do you think?
Yeah, you see now, the problem of us dealing with things after the fact is problematic, because when you are granted an opportunity to redeem yourself early, the Constitutional Court will put itself foot down to say you had ample opportunity to be able to bring these issues before us, and you did not do that. So you have made your own bed, you must simply lie in it. We are not going to chop and change because of the circumstances of this matter to actually favor you, because now if we favor you, we will be giving you preferential treatment. We have already opened the opportunity to hear you on this matter, and then now if we chop and change and vary it because you have brought this information after the fact, when did you become aware of this knowledge of your circumstances of your illness, of your ill health? Did it start when you realized that the Constitutional Court is putting its foot down and saying that no one is above the law and the law must be applied fairly and equally without fear and without prejudice? That's the million-dollar question.
All right, thank you very
much. May I come in on that
Yes,
point?
sure, Professor.
There are two things we need to understand. One is that a rescission application is only granted if there was a fact that has been discovered subsequently that changes the legal conclusion. And the problem is it can't be a fact that the litigant chose not to reveal the first time round. The litigant can't be quiet the first time and they said, hey, and then say afterwards, hang on a minute, you should have considered X, Y, or Z, when the litigant should have brought X, Y, or Z the first time. And secondly, just the point on an appeal. The right to an appeal is part of the trial rights of an accused person, but they're not rights under Section 12, which is the applicable section here, which is just the right to have a hearing before you lose your freedom of person. In other words, before you're imprisoned, you need to have a hearing. That's Section 12 is different. And the majority held in the Constitutional Court that Section 12 applies, and Section 12 had been met because he'd been given multiple opportunities to present his side of the case. But it's not a Section 35 matter. We don't need to worry that he hasn't got a right to an appeal, because this is contempt of court. It's not a normal criminal process.
All right. We are thoroughly enjoying this legal chat. So please stay with us, if you don't mind, Professor Cathleen Powell and Advocate Romeo Nthambeleni. We're going to take a short break and then we'll look at their predictions for what will actually happen tomorrow